Case 26, Witty versus Delta Airlines. We find ourselves in the U.S. Court of Appeals for the Fifth Circuit. Facts. Milton Witty brought this diversity suit in Louisiana Federal District Court against Delta Airlines. He claims that he developed deep vein thrombosis, DVT, while on a Delta flight from Monroe, Louisiana to Hartford, Connecticut. DVT occurs when a blood clot develops in a deep vein, usually in the leg. It can cause serious complications if the clot breaks off and travels to the lungs or brain. Witty alleged that Delta was negligent in failing to warn passengers about the risks of DVT. He asserts in his appellate brief that the warning should be that there is a high risk of developing DVT in pressurized cabins that exceed a certain length of time. The complaint also alleged that Delta was negligent in failing to provide adequate leg room to prevent DVT and in failing to allow passengers to exercise their legs. Delta filed a motion to dismiss, arguing that the state law claims were preempted. The district court denied the motion. The court reasoned that under Hodges v. Delta, state regulation of airline services is preempted, but that state tort actions for personal physical injuries caused by the operation and maintenance of aircraft are not preempted by federal law. The court concluded that Witty's claim arose from the operation of Delta's aircraft and therefore was not preempted. The district court found that the order was appropriate for interlocutory appeal, and this court permitted the appeal. So what's the issue? Whether the legroom claim is preempted by the ADA. The holding. The court held that the order denying the motion to dismiss is reversed, and they rendered judgment in favor of Delta. Let's see why. Federal law exclusively provides the safety warnings that airlines must give passengers, and state law regarding air safety warnings is preempted. Since there is no federal requirement that airlines give DVT warnings, Witty's state claim for failure to warn fails. Let's define some new terms. In U.S. law, diversity jurisdiction is a form of subject matter jurisdiction in civil procedure, in which a U.S. district court in the federal judiciary has the power to hear a civil case when the amount in controversy exceeds $75,000, and where the persons that are parties are diverse in citizenship or state of incorporation, which generally indicates that they differ in state and/or nationality. Diversity jurisdiction and federal question jurisdiction constitute two primary categories of subject matter jurisdiction in U.S. federal courts. The U.S. Constitution in Article 3, Section 2 gives the Congress the power to permit federal courts to hear diversity cases through legislation authorizing such jurisdiction. The provision was included because the framers of the Constitution were concerned that when a case is filed in one state and it involves parties from that state and another state, the state court might be biased towards the party from that state. Congress first exercised that power and granted federal trial circuit courts diversity jurisdiction in the Judiciary Act of 1789. Diversity jurisdiction is currently codified at 28 U.S. Code 1332. An interlocutory appeal, or interim appeal, in the law of civil procedure in the U.S. occurs when a ruling by a trial court is appealed while other aspects of the case are still proceeding. Interlocutory appeals are allowed only under specific circumstances, which are laid down by the federal and separate state courts. In law, the expression trial de novo means a new trial by a different tribunal. De novo is a Latin expression meaning afresh or anew, beginning again, hence the literal meaning new trial. A trial de novo is usually ordered by an appellate court when the original trial failed to make a determination in a manner dictated by law.